creation. In written, the invention must be disclosed in the application in a manner sufficiently clear and complete to enable it to be replicated by a person with an ordinary level of skill in the relevant field. Conditions for obtaining the patent protection. It is always discussed that what is the condition that needed to be for the protection of the patent. The three conditions that is necessity that are necessary for the protection are novelty, inventive step, and capable of the industrial application. If we talk about novelty, it basically means something new. The innovation that is claimed to be protected under the patents is new and not known to anyone in the world. In other words, the innovation is not in the knowledge of the public, not published anywhere through any means of publication, and not to be claimed in any other specification by any other applicant. The second is the inventive step. The inventive step means something that is a technological advancement over the existing knowledge that possesses economic significance and non-obvious to a person skilled in the concerned subject. Something that is new and can lead to the new advancement would be categorized as a patent. And most important is the capable of the industrial application. The invention that is done that would be applicable in the industry and could be benefited by the society as a whole. Rights associated with the patent. We have already heard that. Why do we need for the patent? Why do we need protection of the patent? It is because, as the court of law, a patent owner has the right to decide who may or may not use the patent invention. In other words, the patent protection provided by the law states that the invention cannot be commercially made, used, distributed, imported, or sold by the others without the patent owner consent. The patent owner may permit other party to use the invention on mutually agreed terms. It is the patent owner, the applicant who has got the exclusive right, who will decide how the patent is going to be used, how the patent is going to be applicable in the market, who can use it and who cannot. The patent holder may choose to sue the infringing party to stop the illegal use of the patent and also ask for the compensation for the unauthorized use. If you have a patent registration, you can claim expenses against a person who has unauthorized use of the patent. It is you can also stop the illegal use of the patent and also ask for the compensation. But what is the patent infringement? Once the patent is granted to the applicant, he owns the right to use or exploit the invention in any capacity. If anyone uses the invention without the prior permission of the owner, that act will be considered as an infringement. When you have a patent protection, someone who uses your patent without your information or without your permission can be lead to a patent infringement. Patent infringement is one of the offense that can lead to severe punishments and compensation to be paid. It can be of two categories, that is direct infringement and indirect infringement. Direct infringement is when a product is substantially close to a patent product or in case where the marketing or the commercial use of the invention is carried out without the permission of the owner of the invention. That is basically a intentional infringement, that when the person is aware that he or she does not own that patent or the process but is using it, that can lead to a direct infringement. Indirect infringement refers to when some of the deceit or the accidental infringement happens without any information of the infringement. It is such an unlawful act has been committed. The patent has the right to sue the infringer through the judicial intervention. Every country has a certain laws to deal with such unlawful act. In India, if there is any patent infringement, there can be interim injunction, damages or the profits, accounts of the profit, and the permanent injunction. The person can be asked to completely stop using the process or the mechanism that is leading to the infringement of the application of the patent. Who can file the patent application? In India, the true and the first inventor can file the patent. True and his first inventor's assignee. Anyone related to the deceased person or the representative can file the patent application. According to the Patent Act, a person is any natural person, company, or association, or the body of individuals or government body, whether incorporated or not. In case of the proprietorship form, the application should be made in the name of all the partners. In partnership form, the names of all the personally responsible partner must be included in the patent application. The Applicant is required to disclose all the name, address, and nationality of the true and the first inventor. Usually, when we are filing for the patent application, Form 1 goes where you have to specify the category of the applicant that you are, whether you are a natural person, educational institution, startup, or small enterprise, where you have to specify your nationality, address, name, and everything that may be true to the nature. Now let us see how is the process of patenting that. How can you get a patent registration? In India, the process of patent is a lengthy procedure that may take anywhere 3 to 4 years or more. The major steps involved in the process are listed below. The first is the filing of the application with the IPO, that is Indian Patent Office. Then the application goes for publishing, that is published in the patent journal. Then the application goes for the examination. If the examiner and the controller find the application according to the standards of the patent office, then the application is granted. Registration process first start with the filing of the application. Filing of the application goes with the certain forms, that is form 1, complete specification, and some other forms. Form 1 specifies all the name of the applicants and the inventors with the nationality, address, and the category of the applicant. Second important and the most important form is the complete specification, or the form 2, where you have to describe your invention in every detailed and prescribed form, where you have to mention the summary of the invention, title of the invention, how your invention can be novel and has an inventive step, the claims, the abstract, and everything should be mentioned in the complete specification. The fees for filing an application in the Indian Patent Office would be 1600, plus extra some charges may be applicable. Then the application goes for the publication, that is in the patent journal, which usually takes around 3 to 4 months to get your application published for the and get in the public domain. But if you want an early publication, you can file for the early request or for the publication, that is with the form 9, that also consisting of the fees of 2500. Early request for the publication ensures that your application is published very on the urgent basis, and it requires only 15 to 30 days to get your application published in the journal. After the application is published, the request for the examination is compulsory. Without that, the application would not move further. Request for the examination can be filed within the 31 months from the date of filing. Request for the examination can be filed by two ways, that is in the consideration of Form 18 and Form 18A. Form 18 is the request for the early examination, that would be costing around 4,000. And 18A form consists of a request for the expedited examination, that would require 8,000 as the fees. When the request for the examination is filed, the application moves further for the examination, where the controller and the examiner examines the application, after which an FER is issued. FER is referred as first examination report, where all the objections stated by the examiner are stated. The applicant is responsible to answer all of these within the 6 months of the date of receipt of receiving the application. After the FER response is filed, the application goes for the pre-grant opposition, where a hearing is scheduled, and the examiner examines the claims that have been mentioned and everything. And if the examiner thinks that the application is suitable, the application is granted. After grant, if it is further found that some of the applicant have the same mechanical process or similar invention, the other applicant can file an opposition as an opponent, where again the process would be filed, where the same document would be there, and people have to file for the objection, state for the counter statements and everything, so that we can prove that our invention is different from there, so that our grant is not cancelled. Now let us see for the term of the patent. The register of the patent contains the name and address of the patent. After the application is granted, a registration certificate is issued by the patent office, which specifies the name of applicant and every stuff, the name of the application, the invention, the date, and it also specifies the term of the every patent in India, that is 20 years. Since the patent is granted, you will be getting the protection for the 20 years. Some patent related forms that are necessary. The form is one, that is application for the grant of patent. It specifies the name of all the applicant, inventors, title of the application, and all the necessary documents that are going with the application. The second contains the provisional and the complete specification. Provisional specification is a specification that does not have the complete a specification. That means the invention has only been done, but the complete work has not been done. So just to protect the invention, you can file for the provisional application, where from the date of filing, after the 1 year, you need to file a complete specification, where the specification has all the knowledge, all the information, like the summary, the title of the invention, and every stuff. Then goes the form 3, that is the statement and undertaking under the section 8, signed by the applicant. Another form goes the form 5, that is a declaration as to inventorship, that is signed by the inventors. That another goes for the form 9, that is request for the early publication. Form 18 for the request for the examination of the application, and 18A request for the expedited examination. Form 26 goes the power of attorney. If you are using it to the patent agent, you need to sign this so that he or she can act on your behalf. One of the major case laws of the patent infringement was Apple versus Samsung case, initiated in 2011. Is one of the most high-profile patent infringement cases in the recent history, involving two parts of the technology world. Apple accused Samsung of copying key design elements and functionalities, such as pinch-to-pinch zoom feature and the rectangular design with the rounded corners that were patented by the Apple for its iPhone. Samsung countersued, claiming Apple had infringed one of the some of its own patents, and the case spiraled into a lengthy legal battle that spent years. The case was notable not only for its scale, but also for its long-lasting impact on the smartphone industry. It set important legal precedents concerning that what can and cannot be patented, particularly in terms of software and design elements. Beyond circles, the case fueled discussion about the balance between fostering innovation and stifling competition. It taught about how proprietary technology should be in an industry built on it and collaborative development. Now let us move further to the copyright. A copyright refers to the legal rights provided by the law to the original creator of the work in the fields of literature and the computer software. The related rights encompasses the author's work in the field of dramatic, sound recordings, film, video recording, paintings, architecture, etc. Copyright and related rights are one of the categories of IP governed by Copyright Act of the India. This act provides rights of reproduction, communication to the masses, adaptation, and translation of the work. Copyright is used to protect the work that can be literally in nature, that are poems, poems, dramas, and all that stuff, and the software that can be the codes for these things. Now let us see what is the classes of the copyright. In India, the following classes of the copyright exist. That is literature, mathematics, sound recordings, artistic, music, and film. Books, essays, research articles, oral speeches, and the computer art and the software database come under the category of the literature. Artistic refers to the drawing, painting, logos, and the map. And some of the musical notes and the films can be copyrighted. Copyright infringement: when someone uses your work without your prior permission, that leads it to the infringement. So when someone uses your poems, your artistic work without your prior rights and permission, it leads to the copyright infringement. As per the Copyright Act 1957, the following acts are regarded as the infringement of copyright: making copies for the sale or hiring of the selling or letting them for hire without the permission, permitting any place for the performance of own work, distributing infringing copies for the trade or to such an extent to affect the interest of the owner of the copyright, public exhibition of infringing copies for the sale. Digital created works and copyright works transformed into a digital format and placed on are protected. It is not if someone swipes up the copyright registration for a website as a whole is not possible. So it is important that we set the codes for the registration so that a website can be registered. A computer or a mobile app qualifies for copyright registration. An application is complete self-contained computer program that is designed to perform a specific task. If someone swipes your pictures, song, videos from the internet and uses it for their purpose, it is a copyright infringement. By the way, the same is true if you nick someone else's material for your purpose. The AI infringement on all these copies that the AI is using to infringe someone privacy and someone privacy and all the stuff will also lead to a copyright infringement. It is not necessary to register a work to claim copyright. Once a work is created via any medium, the work receives automatic copyright safety. A copyright registration provide you a plus one in advantages so that in the any of the legal proceedings, it can safeguard you as the work. In India, copyright matters including copyright registration are administered by the Copyright Act 1957 and copyright rules 2020. Now let us see how copyright is registered in India. First, it is the filing of the application along with the fee. Application filing can be done either by physical form or by online way. By for the physical form, the application has to be submitted in the Indian Copyright Office, Delhi. But whereas for filing, you can directly go to Indian Copyright Office, Indian Copyright website, and where you can file for the application. The necessary documents would be the applicant details and every details related to the applicant. That would be its nationality, address, and every stuff. And also a copy of the work that is need to be copyrighted. Once you have paid the submitted the document, you have to pay the fee of rupee 500. Once the fees has been paid, the issue of a diary number is there. The diary number specifies the special identity of the work that can be used for the further transfer of the records. Then there is a 30 days mandatory waiting period for the objections from the other party. If there is no objection filed, there is scrutiny done by the office where a discrepancy letters are submitted to the applicant where they have to clear all the discrepancies. From discrepancies may be related to the class of the work or the stuff which the office may find not suitable. But if the objection is filed, letters are sent to both the parties, and the applicant is responsible to find a reply. And then there is an hearing issued by the registrar. If the application is accepted, the application goes for scrutiny, and the further the process continues. If there are discrepancies later, and a registrar finds the reply suitable and done, the hearing may be scheduled. Hearing may be scheduled by the registrar for the statements for proving that the documents are proved right. When it is done and the registrar is satisfied, the copyright information is provided to the applicant. One of the major copyright cases where we can see is that the father of the renowned actor Mr. Amitabh Bachchan, Sri Harivansh Rai Bachchan, was a noted poet and a Hindi writer. His famous work was Madhushala. He was the recipient of the and the Padma Bhushan. He also did Hindi translation of the Shakespeare's Macbeth and Othello. He passed away on 19 January 2003 at the age of 93. As per the Copyright Act, the right over the work was completed in the year 2016. That means that the as soon as the work is in the public domain, it is protected for the entire lifespan of the applicant or the creator of the work, which would be remain for his lifetime plus 60 years after his death. Now let us see what's trademark. Trademark is one of the major IP that is growing its market and stability in the economy. In simple language, a trademark is a unique symbol which is capable of identifying as differentiating products or service of the one organization from those of the others. The word mark stands for mark, design, phrase, slogan, symbol, name, numeral, devices, or a combination of these. Essentially, the trademark is anything that identifies a brand to common consumer. Any person who is a proprietor of the trademark is eligible to apply for the registration of the trademark. In India, trademarks are governed under the Trademarks Act 1990, and the trademark rules are governed by the Trademark Rules 2000. In India, a registered trademark is valid for 10 years. The period can be extended every 10 years perpetually. Trademark is a mark which can be used as identification for the business or a different identification that is used by the businesses to make their business stand out in the market. It can be a word mark, logo mark, a device mark, sound mark, and or the smell mark. Usually in India we don't have sound marks and the color marks. But if we talk about the word mark, device mark, and slogan mark that are prominent in India, for example, word mark would be McDonald's. But if we talk about device mark, the M sign that is in yellow color would be a device mark. The slogan mark would be the tagline that is using, that is I am liking it. That is a trademark that make it stand out. Like McDonald's has its registered trademark. Criteria to get a trademark. It can be basically categorized as distinctiveness and non-descriptiveness. Distinctiveness refers to the marks and the goods and services for which the protection is sought should be possess enough uniqueness to identify it as a trademark. It must be distinctive. It should not be similar to the any existing mark. It should be phonetically, structurally, visually different from the registered trademarks. Descriptiveness. The trademark should not be describing the description of the concerned good of services. If you are using a trademark for a particular goods, it should not be describing. Like for example, but if it has equivalent secondary meaning, then it could be registered. Like the brand name Apple. Classification of the goods. Goods and services under the trademarks are classified as per the Nice Agreement 1950, administrated by WIPO. WIPO stands for World Intellectual Property Organization. A total of 149 countries who are signatory to the agreement in 65 additional states follow this classification. Under this classification, there are 45 classes for which classes 1 to 35 are devices and 36 to 45 are devices. Class 1 is for the chemicals used for the industry. Class 25 is for clothing, footwear, and headgear. Class 44 is for medical services, horticulture, forestry services, hygienic, and the beauty care. Class 35 is for services related to advertising, business administration, and business management. Now, let us see how the trademark is registered in India. First, you are responsible to see search the trademark. That is, the mark you are seeking registration for does not matches with the already existing trademarks. After that is done, you need to classify that in which class it would fall. Then after then, application is filed with the trademark registry. The trademark registry, after the submitting of the organization, examines it and see that if there is objection. Usually, the objection come under the Section 9 and Section 11 of the Trademark Act, under which the marks can be fall under the grounds for the relatives and the absolute grounds. If the mark is descriptive or same compared to the other mark, objection can be there. For that, an FER is issued, that is the first examination report, and the applicant is responsible to file the response to it within the 1 month of the application. After the FER is submitted, if the registrar find it suitable and think that the objections were non-containable, the application is accepted and it is published in the journal. After the application is published in the journal, trademark open for the public for the 4 months to find to file any of the opposition. If the any of the opponent thinks that the mark is similar to their existing trademark, which could hamper the reputation or any, the opponent can file for the opposition within the 4 months since the application is published in the journal. Counter statement has to be filed by the opponent, for which a notice of opposition filed by the opponent, and for which the counter statement has to be filed by the applicant within 2 months of the date of receipt. After the counter statement has been filed, if there is any schedule, that is the opposition, both the parties would be present there to put their points forward, and it would be after the registrar that the trademark would be getting registered. If there is no opposition, the mark would be registered directly. Designation of the trademark symbols. Sometimes some mark uses R. The R shows that the mark is registered, and the R is the legal proprietor of he is the legal proprietor and the owner of the mark and can be used. SM represents the trademark is unregistered being used for the services. It can be used when the mark is accepted and published in the journal. And the TM represents the mark that is unregistered. This mark can be used for promoting the goods of the company and the stuff. Registration of the trademark. We've always heard that registration of trademark is important. You should go for the registration, but what are its advantages? How can it be beneficial to the innovators and the creators and the entrepreneurs, the businesses that are seeking for the registration of the trademark? Some of the benefits that the registration of the trademark provides is the legal protection, exclusive right, brand recognition, legal protection. It prevents the mark from being exploited. The infringement of the mark cannot be done. And if it happens, it would be very serious. It can lead to a punishment have to be compensation have to be directly applied if the mark has been in exclusive right. Trademark registration makes you the exclusive owner of the mark. The owner gets the full rights to use it in any lawful manner to promote his business. The third and the most important point is brand recognition. Having registered trademarks help you for the brand recognition. It is the market position. It leads to the promotion of your businesses that can lead to more customers, more economic activity, profitability of the business. Asset creation. As discussed, IPs are an intangible property of the organization. It can be used and it is used as an asset for the brand identification and its resources. Trademark registry in India, the operation of the trademarks are carried out of five cities, that is Delhi, Mumbai, Ahmedabad, Kolkata, and Chennai. Each city has been assigned a separate state. Once you file a trademark from the state, you will be getting an office location based on your jurisdiction that would be responsible for all the matters and handling. Famous case law for was of was Coca-Cola Company versus Bisleri International Private Limited. Maza, a popular mango fruit drink in India, is registered trademark of the Indian company Bisleri International. The company transferred the rights to the beverage company Coca-Cola for the Indian territory. However, in 2008, the Bisleri company applied for the registration of the trademark Maza. The Indians started exporting Maza. Maza was unacceptable to the Coca-Cola company and thus the company sued for the injunction and damages for the passing of the infringement in the trade. As discussed about the jurisdiction of the mark, a mark is registered in any of the country. You can only use it in that country only. That was the most of the prominent cases that specified the jurisdiction. Or it is saying what is design. The word design defined as the features, shape, configuration, pattern, ornament, or the composition of lines or the colors applied to the product. The design may be of any dimension, two or more three-dimensional combination of these. Design is usually registered for the configuration or the special element of the feature of the product. It is not given to the product or the name of the product, but the special features of the product, like the Coca-Cola bottle or the different containers that can be used to take the design registration. Design does not include any mode or principle or of the construction or anything which is in the substance a merely mechanical device. It is about the configuration and the pattern of the product, not any mechanical device or anything. In India, industrial designs are governed under the Design Act 2000, Design Rule 2001, which have been amended from time to time in 2008, 13, 14, and 19. The design should include the following characteristics. The necessity for design registration in India is that it should be novel and original. It should be aesthetically or functionally pleasing. It should be designed with the intent to identify the product or the service of the customer. It should be visually pleasing. These characteristics are essential for the registration of the trademark. Without the registration of the trademark, or any initial registration design of the mark, the intent of the business or the application has been incomplete. Therefore, the design should be identified with the registration of the mark. Once the mark is registered, the design should be identified with the registration of the mark. The design. If the design is found to be registered, there will be no legal action. If the infringer is found guilty of the piracy or infringement, the court can ask him to pay the damages 50,000 in respect of the infringement of unregistered mark. It is important to get your design registered register so that if anyone using your rights without your permission, you can at least exclusively use your rights and ask for the damages. In India, we start with the design application. After the design application goes in the form of application and power authority to reside in. It consists of the details of the application, title of the design, and the class of the design. Class of the design under the design is commercial Locarno classification. The representation consists the views of the design. Consists of the perspective view, front view, top view, right view, left view, and the side view. The copies of the each image has to be submitted to the office for the registration. After that, a formality check is done by the registry. If any of the issues are found, FER is issued. For which the reply has to be filed within the 6 months. If the that the application has been overcome, the application is accepted and it is given the registration. If the objection have not been overcome, he or she may issue a hearing that has to be attended by the applicant. After the design is accepted, it is published in the journal for the 1 month, so that if any of the similar design already exists in the market, that can be opposed by the opponent. After that, if no opposition is issued, issuance of the certificate is there. The term for the design is 5 years and it is valid for the 5 years. After the registration, if anyone finds that the similar design has been registered, they can file for the cancellation of the opposition for the procedure. The famous Apple India versus Samsung Electronics Company. In 2011, Apple filed a case against Samsung Electronics in the United States District Court for the Northern District of the California, infringing their design and utilization of the icon, algorithm, and tap to zoom. As evidence, Apple submitted the side-by-side image comparing the iPhone 3GS and the i9 Galaxy S to demonstrate the alleged similarity in both the models. However, later it was found that the images were tempered by the dimension of the controversial design. So it's if any design is being registered and matches the other design, you can go for the infringement and claim your compensation by the court. Trade secret is a form of IP that deals with the practice or process of a company that is generally not known outside the company. The confidential secret provides us generally a commercial advantage over its rivals and is often a product of internal research and development. Trade secret includes confidential information involving manufacturing processes, experimental research data, formulas, recipes, software algorithms, and the Patent, trademarks, copyright, design, and trade secrets, and how each plays a vital role in encouraging creativity and safeguarding original work. I would like to close with the quote that perfectly captures the essence of IP. Innovation is the currency for the future, and intellectual property is the strongest bank. Thank you once again. I will now be happy to take your questions.
Any having any question, kindly address it to ma'am. If anyone has any question, any query. If you have any question related to how to file design patent, utility patent for Indian patents, German patents, and also other copyright mark related issue regarding your own product, kindly consult it to ma'am, or ask your doubts. She is there to reply all of your queries.
Insightful session. We truly appreciate your time and insights and are grateful for your presence today and all wish you to have such valuable talks over and again in the coming day. On behalf of IIC, we heartedly thank our respected Principal Sir, IQAC Coordinator, HOD Department of CAC Department Molloy Sir, respected Molloy Sir, and also all the respected IIC faculty member, and also all the faculty member as well as students of the institute, and lastly, the student coordinator of IIC. Thank you all for your warm presence today. Best wishes here, and we end our today's program. Thank you so much for having me.
Thank you, ma'am.
Thank you so much, sir.
এটা কতদূর হয়েছে বোঝা যাচ্ছে না, এই যে এরকম একটা এলার। ও, তারপর থেকে আমি আর ওটা ট্র্যাক করতে পারছি না যে হয়েছে কি। এ তো শেষ যতটা হয়েছে, কিন্তু রেকর্ডিংটা একটু দেখতে পারি, রেকর্ডিংটা একটু কেটে দেবো। হ্যাঁ হ্যাঁ, মানে